Hello, my name is Ali Carter. I am the founder of Mediate UK, and one of the questions we are often asked is, what is a child arrangements order and how do we make our parenting plan legally binding? So let's have a look at those today. A child arrangements order is an order by the court that makes your arrangements legally binding. So it would normally cover where the child is going to stay and when, what's going to happen with holidays, what's going to happen at Christmas, birthdays, special occasions, and how the child is going to see their parents, and even can cover wider family as well. So it won't cover off things such as how you discipline a child, what you say to a child, how you're going to raise the child. Those are things that the court can't control or cannot make orders on. So it's quite specific, and it's deliberately quite a watertight area so that there's no confusion on it. It will stipulate days and times normally. So as the child grows up, that order will normally need to change, and you can get into this cycle of keep going back to court every time you want to change, or even if you can agree a change between yourselves to update the order as the child grows older. So they are best avoided except for certain extreme examples. This then throws open, well, what can we do if we want to have our arrangements legally binding to protect us, but you're saying don't get a child arrangements order? Well, there's something called a no order principle in the courts, and that's because the courts recognise how inflexible these orders are and that they might not always be in the best interest of the child. So to get one, you have to show, as parents, why it's in the best interest of a child to have such an order. A parenting plan is different. A parenting plan is arrangements that you are going to agree as parents on how you're going to raise the child whilst living separately. That's this problem that needs to be solved. And this could cover off many things, such as what's going to happen with their clothing to swap over, arrangements for toys, all of these wider things, principles that you agree, might be some religious principles around disciplining a child. All of these things you can agree and put into a parenting plan, and then you can update that plan as you move along without going to court. So it's far more flexible. It's not legally binding. So if you want to make your parenting plan legally binding, you can apply to the court and say, we want to have this made legally binding. It's still called a child arrangements order, but it will be by consent. But again, you will have to show the court why it's in the child's best interest, not the parent's best interest, why it's in the child's best interest to have that made into a child arrangement order. You have to go to court yourselves because it's to do with children. They will want to speak to both the parents and anyone else with parental responsibility. And also they will probably want CAFCAS to get involved to check the background into the parents and to speak to the children as well. So it's not just a case of a judge signing off or stamping an order. There's quite a lot to it. We're dealing with children. The court don't know your children. They have to do quite a bit of investigation before they will make an order that could potentially be restrictive on the child's life. To apply for a child arrangement order, you need to complete a form called a C100. Most of that form is to do with mediation exemptions and considerations. There are 15 exemptions. Have a look on our website, they're all listed there. But for most people, you will need to at least consider mediation by way of attending a mediation information assessment meeting called a MIAM, or attempt mediation, and you can show that you've done that and that it's broken down. The other thing with a parenting plan to bear in mind is that as the child grows up, the older they get, the more input they should be having into that. It's a child arrangements order, it's not a parenting arrangements order. Therefore, the child's needs and wishes are very much taken into consideration by the court, and as they get older, more weight is put on that as they're able to vocalise and understand their own feelings and wishes better. So much so that when they get to 16, it is highly unlikely that a court would even consider listening to your case unless there are exceptional circumstances there. So I hope that's helped. That's a child arrangement order, the difference between one and a parenting plan, and how to have it made legally binding. we offer a free 15-minute consultation where we can go into more detail about this in your specific case. So do give us a call on 0330 999 0959, and our contact details are at the end of this video. Thank you.